Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about Beaver. Sean Beaver. Cases that should have gone to the Supreme Court of Canada, but didn't. Sean Beaver was a lawyer in Alberta. Ultimately, he was disbarred, but leading up to his disbarment, he was suspended from practicing law. While he was suspended, he was determined to have been practicing law and ultimately placed by the court on injunctions not to practice law. After his disbarment, he was found again to be practicing law, and the court determined that he was acting in violation of his injunctions. He argued that the injunction that prevented him from practicing law while suspended expired upon his becoming disbarred as a result of a material change in facts. The court did not agree, and ultimately he tried to raise the issue before the Supreme Court of Canada but was denied. This does raise an important question, though, because although injunctions can function to prevent a person or an individual or a group from engaging in certain actions based on a certain set of circumstances, if there is a material change in circumstances, then the injunction shouldn't just necessarily continue to apply. The injunction is meant to prevent a specific harm in a specific situation. And if that specific situation no longer exists, then the harm that is meant to be prevented by the injunction might no longer be realistic. Obviously, in Mr. Beaver's case, practicing law while you're suspended versus practicing law while you're disbarred doesn't really change much as far as the harm that's meant to be avoided. But at the same time, setting up the law in such a way that an injunction essentially applies even if the circumstances change until it's either expired or until it's canceled by the court raises significant concerns that people who are the subject of injunctions, where there has been a material change that no longer justifies the imposition of injunctions, are nevertheless going to be prosecuted for contempt for failing to comply with those injunctions. And it takes the power of an injunction to limit the rights or exercises of discretion of individuals and increases that power to a way that a temporary measure isn't really supposed to function. This is a significant concern, and the Supreme Court of Canada should have recognized that while Mr. Beaver's situation was obviously not one justifying removal of an injunction, the law surrounding this area did require some commentary about when material changes in circumstances could lead to the automatic expiration of an injunction. And missing that opportunity, I think, was a very big concern. Hopefully this doesn't function to create situations where individuals who are engaged in protest behavior, like we've seen with pipeline protests, with oil sands protests, and all sorts of other protests related to environmental concerns, Indigenous protests, Black Lives Matter protests, and other types of protests that have been aimed at advancing societal interests are somehow now prevented from ever continuing as a result of injunctions, even when there are material changes in circumstances. I hope the Supreme Court of Canada has an opportunity to reconsider the way that the injunction rules have essentially been implied as a result of Mr. Beaver's case. But really, this is, I think, an example of bad cases and bad facts making bad law. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.